Did 3M Philippines Incorporated lawfully terminate Lauro D. Yuseco's employment on the ground of redundancy, or was this a veiled act of illegal dismissal aimed at unjustly removing a high-ranking officer? This is the case entitled 3M Philippines Incorporated vs. Lauro D. Yuseco, GR number 248941, November 9, 2020. This is the first case of 327 cases decided by Associate Justice Amy C. Lazaro Javier, the bar chairman of the 2025 bar examinations. Subscribe to this channel to receive case digest and reviewers relating to the 2025 bar examinations.
Facts of the case. Lauro D. Yuseco had been employed with 3M Philippines since 1997 and held the position of country business leader with a monthly salary of Php 271,000. On November 25, 2015, Yuseco was called to a meeting with the Managing Director, Anthony J. Bolzan, and Human Resources Manager, Maria Teresa Cayongbian. During this meeting, Yuseco was presented with a supposed request for separation, which he had never made. He was asked to sign a waiver and quitclaim, which he refused. The next day, Bolzan announced via email that Yuseco would be pursuing opportunities outside the company, causing embarrassment to Yuseco. Shortly thereafter, Yuseco received a formal notice stating his position was redundant effective January 1, 2016. 3M Philippines offered Yuseco a separation package, which included P5/254/402.12 in benefits. Yuseco countered, demanding a separation equivalent to 25 years' salary, which the company refused. He then filed a complaint for illegal dismissal. Labor Arbiter's ruling. The labor arbiter ruled in Yuseco's favor, declaring his dismissal illegal and awarding him back wages, separation pay, moral and exemplary damages, and attorney's fees. The arbiter found that the redundancy claim was merely an afterthought, given the inconsistent justifications provided by the company in its communications. National Labor Relations Commission, NLRC, ruling. Upon appeal, the NLRC reversed the labor arbiter's decision, finding that Yuseco's termination was valid due to redundancy, backed by a corporate reorganization in line with 3M's international operations. The NLRC also found that 3M Philippines had followed the proper legal procedures, including notifying the Department of Labor and Employment, DOL.
Court of Appeals ruling. Yuseco appealed to the Court of Appeals, which reversed the NLRC decision, declaring the dismissal illegal. The appellate court found that 3M Philippines failed to provide sufficient evidence of redundancy beyond a mere affidavit and ruled that Yuseco should be reinstated or given separation pay if reinstatement was no longer feasible. Primary legal issue. Did 3M Philippines lawfully terminate Lauro D. Yuseco on the ground of redundancy, or was this a case of illegal dismissal? Supreme Court decision. The Supreme Court ruled in favor of 3M Philippines. It held that redundancy is a valid cause for termination under the Labor Code and is considered a management prerogative. The court found that the redundancy program was carried out in good faith as part of a genuine corporate restructuring effort. The company provided substantial evidence, including affidavits and compliance with legal procedures, such as proper notice to DOL and a generous separation package. The court ruled that Yuseco's dismissal was legal, and 3M Philippines had complied with the requirements for redundancy, including fair selection criteria and good faith in abolishing redundant positions. It emphasized that an employer is not obligated to retain more employees than necessary, even if a business is profitable.
Dispositive portion. The Supreme Court reversed the decision of the Court of Appeals and upheld the validity of Yuseco's termination due to redundancy. 3M Philippines was ordered to pay Yuseco the separation package as computed and presented during his termination. In cases of redundancy, where should the line be drawn between legitimate business decisions and the possibility of using redundancy to remove employees unjustly? Important doctrines. 1. Redundancy as a valid cause of dismissal. Article 298 of the Labor Code. Redundancy exists when the services of an employee are no longer necessary to meet the demands of a business enterprise. This can be due to a variety of factors, including the introduction of labor-saving devices or business reorganization. Point 2. Employer's prerogative in organizational restructuring. The employer has the right to restructure its organization and declare positions redundant, provided it is done in good faith and with reasonable criteria. 3. Good faith in implementing redundancy programs. Employers must show that redundancy was implemented not as a means to unfairly terminate employees but as a legitimate response to business needs. For proof of redundancy, employers must present more than just affidavits. Supporting documents and compliance with legal procedures, such as notices to employees and dole, are required.